That was really an impressive group out there on the stairs, on the north steps, celebrating the signage of HB 1013. And once again, I appreciate the work of everybody in this chamber on that. Our Dr. Caucus, all the committee members, and all of you who voted in favor of that legislation. Truly impactful and something I will remember for a lifetime. At this time, I'd like to recognize the senator from the 19th for a motion.
Thank you, Mr. President. I move that the Senate disagree to the House substitute to Senate Bill 374.
Ms. Secretary, can you please read a caption?
Senate Bill 374, a bill by Senator Tillery of the 19th and others, a bill to be entitled an act to amend Part 3 of Article 4 of Chapter 12 of Title 45 of the OCGA relating to Georgia Data Analytics Center, so as to provide for definitions, to establish the Georgia Data Analytics Center as an agent of all executive state agencies and for other purposes. That completes the order, Mr. President.
Would the senator from the 19th wish to speak to his motion? The senator from the 19th has moved that the Senate disagrees to the House substitute to Senate Bill 374. Is there objection? The chair hears none, and the Senate has disagreed. We have a resolution creating a study committee that was inadvertently left off today's consent calendar, creating study committees, which we adopted a few days ago. At this time, I'd ask the Secretary to read the Senate Resolution 615.
Senate Resolution 615, a resolution by Senator James of the 35th and others, a resolution creating the Senate Property Owners Associations, Homeowners Associations, and Condominium Associations Study Committee, and for other purposes. That completes the order, Mr. President.
Is there objection to adoption of the resolution? The chair hears none, and the resolution is adopted. Chair recognizes the senator from the 18th.
President, I'd ask for unanimous consent to take HB 916 off the table.
Ms. Secretary, can you please read the caption?
House Bill 916, a bill by Representative Leverett of the 33rd and others, a bill to be entitled an act to amend Title 5 of the OCGA relating to appeal and error, so as to provide for a unified procedure for appealing decisions of a lower judiciary to a superior or state court, to repeal and reserve Chapter 4 of said title relating to certiorari or to superior court, to amend various titles of the OCGA, so as to provide for conforming changes and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
Senator from the 18th has asked that House Bill 916 be taken off the table. Is there objection? The chair hears none, and it's removed from the table. The chair recognizes the senator from the 18th to speak to the measure.
Thank you, Mr. President. Good afternoon. As we start our final trek toward midnight, or the last bills that we're going to pass. HB 916 is a long, somewhat difficult work of a lot of people in trying to revise certain portions of the Civil Practice Act in which lawyers and all of us litigants who have cases in the magistrate court, civil courts, and lower courts that are those that are below the superior court level. And the process that we have now is old, it is arcane, and as the folks that presented it to the Senate Judiciary Committee joked, we're trying to advance us maybe into the 1960s or 1970s with these actions. But in essence, what we are providing is a substantial overhaul of the process of appealing lower judicatories in the state and superior court, and it provides a single unified process for such review. What we have currently is very disjointed. It requires and applies different rules depending upon exactly what's going on. It has service requirements that are from olden times where the judge is actually served and made a party to the appeal. It's very cumbersome and very confusing. The difficulty with this is it winds up that most of the people, many of the litigants, the vast majority of the litigants that are appealing to the superior court through this old arcane way wind up having their appeal dismissed because of technicalities and not being heard on the merits. So this long time and long-term frustration with this difficulty has produced a committee and literally 3+ years of work trying to figure out a better way to move forward. And that's what we have before you now. This comes to you unanimously from the Senate Judiciary Committee. It also comes unanimously from the House body with a 167-0 vote. This will help us move into a more modern process. It'll make sure that litigants are heard on the merits and that lawyers, and especially pro se litigants that can't afford lawyers, will not be tripped up by the rules of procedure instead of having their case actually heard by the higher court into which they're appealing. That's the sum and substance of it. Happy to answer any questions, or I'll be happy to yield the well.
You don't appear to have any questions.
Thank you, Mr. President. I urge your consideration and positive vote for this. Thank you.
Does any other senator wish to speak for or against House Bill 916? The chair sees none. Is there objection to agree in the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Question on the passage of the bill. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 16th. I believe you want to ask me something about House Bill 1045.
Move it off the table, man. It's consent. I was like, me? You? Me?
No. If I may, sir, I would like to table it, if I will, for right now. May I table it?
Speak up a little bit.
May I table that bill?
It's already on the table.
Already on the
You
table.
want to leave it on the table?
Leave it on the table, please, sir.
Senator from the 16th has requested that it remain on the table.
Table.
Chair now recognizes the senator from the 42nd.
Thank you, Mr. President. I'd like to ask for unanimous consent that HB 1405 be taken from the table.
Ms. Secretary, can you please read the caption?
House Bill 1405, a bill by Representative Roberts of the 52nd and others, a bill to be entitled an act to amend Title 36 of the OCGA relating to local governments so as to revise the zoning procedures law, to revise provisions related to judicial review of zoning decisions, to revise definitions, to provide for requirements for zoning decisions by boards or agencies using delegated powers, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th District Chairman. Mr. President, the Senate Judiciary Committee offers the following substitute to House Bill 1405, a bill to be entitled an act to amend Title 36 of the OCGA relating to local governments so as to revise the zoning procedures law, to revise provisions relating to judicial review of zoning decisions, to revise definitions, and for other purposes. Mr. President, Senator Parent of the 42nd District and others offered the following amendment number 1 to amend the committee substitute to House Bill 1405 by striking the word only on line 208 and inserting substantively in its place. Mr. President, Senator Parent of the 42nd and others offered the following amendment number 2 to amend the Senate Committee on Judiciary substitute to House Bill 1405 by inserting after powers on line 4 the following: to provide additional notice and hearing provisions for changes to zoning ordinances that revise single-family residential classifications and definitions so as to authorize multifamily residential property uses and for other purposes. That completes the order, Mr. President.
Senator from the 42nd has asked for House Bill 1405 to be taken from the table. Is there objection? The chair hears none, and it's removed from the table. The chair now recognizes the senator from the 42nd to speak to the measure and the amendments.
Thank you, Mr. President. Colleagues, it is my honor to bring before you a very good lawyer bill. House Bill 1405 codifies Georgia zoning law procedures by clarifying which type of zoning disputes will be determined through a legislative versus a quasi-judicial process. The legislative zoning process includes city councils and zoning offices, while a quasi-judicial process includes zoning appeals boards that issue case-by-case decisions.
Senator, will you stand by for a moment? I would ask that each and every senator give your undivided attention to the senator in the well. I get it, it's the last day, but these are important measures for all of us to consider before we cast our votes. If you have a conversation that's not privy to the voting machine in front of you, I'd ask you to take it off the floor. Thank you.
Thank you, Mr. President. This bill details the evidentiary standard the Superior Court will use upon appeal and other procedural details. It will add efficiency and clarity to current zoning law in Georgia. It is supported by zoning attorneys, ACCG, GMA, and the Georgia Realtors. You will see in front of you 2 amendments. The first amendment deals actually, is a very small change, but it necessitated by the bill that we just passed, presented by the senator from the 18th, HB 916, the Appellate Practice Act. This change means that the process laid out in 1405 will work within the confines of House Bill 916. And the second amendment also deals with zoning procedures. It is another bill that actually just kind of ran out of time in the House, but is agreed to by all of our local advocates down here as far as ACCG and GMA. And what it essentially does is sets out some notice provisions for when a local government is planning to change from single-family zoning to multifamily zoning. So it just sort of details the transparency and notifications and hearings that will be required in that instance. That's the bill. Very, very good bill. Happy to answer any questions, if there are any, Mr. President.
You have a few questions. Chair recognizes the senator from the 19th to your left with a question.
Thank you, Mr. President. Senator Yield.
Absolutely.
Senator, Amendment 1, can you walk us through, we're just trying to figure out how that word changes, if you don't mind.
Yeah.
Walking us through that.
So, so in the original bill, we referenced a specific part of Chapter 5 that was related to the certiorari process. And then as HB 916 was moving, we realized that that could replace certiorari with a different appeals process. So now the bill is revised to generally reference Chapter 5. So regardless of 916 making it all the way through or not, this bill will work if 916 achieves final passage and is signed, or if it doesn't.
You don't appear to have any more questions.
Thank you, Mr. President. I ask for favorable consideration for House Bill 1405, and I yield the well.
Chair recognizes the senator. She waves. All right, any other senator wish to speak for or against House Bill 1405? The chair sees none. We'll take up the amendments. Is there objection to adoption of amendment number 1? The chair hears none, and amendment number 1 is adopted. Is there objection to adoption of amendment number 2? The chair hears none, and amendment number 2 is also adopted. The question now is on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute as amended is adopted. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Thank you. Chair recognizes the senator from the 52nd.
Mr. President, I move that the Senate adhere to its substitute to House Bill 1437 and that a conference committee be appointed.
Ms. Secretary, can you please read the caption?
House Bill 1437, a bill by Representative Blackman of the 146th and others, a bill to be entitled an act to amend Chapter 7 of Title 48 of the OCGA relating to income taxes so as to revise the rates of taxation on income and for other purposes. Mr. President, the Senate Committee on Rules recommends that this do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd District Chairman. That completes the order, Mr. President.
Senator from the 52nd has moved that the Senate adhere to its substitute to House Bill 1437 and that a conference committee be appointed. Is there objection? The chair hears none and appoints the senators from the 30th, 51st, and 52nd as our conferees. Best wishes. Chair recognizes the senator from the 24th.
Mr. President, I ask that House Bill 1384 be lifted from the table.
Mr. Secretary, can you please read the caption?
House Bill 1384, a bill by Representative Jenkins of the 132nd and others, A bill to be entitled an act to amend Code Section 8-2-23 of the OCGA relating to amendment and revision of codes generally, so as to require the department to amend the Georgia State Minimum Standard Codes to authorize certain uses of ungraded lumber and for other purposes. Mr. President, the Senate Committee on Agriculture and Consumer Affairs recommends that this bill do pass by substitute. Respectfully submitted, Senator Walker of the 20th District Chairman. Mr. President, the Senate Committee on Agriculture and Consumer Affairs offers the following substitute to House Bill 1384, a bill to be entitled an act to amend Code Section 8-2-23 of the OCGA relating to amendment and revision of codes generally, so as to require the department to amend the Georgia State Minimum Standard Codes to authorize certain uses of ungraded lumber and for other purposes. That completes the order, Mr. President.
The distinguished senator from the 24th has asked that House Bill 1384 be lifted from the table. Is there objection? Chair hears none, and it has been lifted. Chair now recognizes the senator from the 24th to speak to the measure.
Thank you, Mr. President. This is a great bill for the great people of the great state of Georgia. This bill makes it to where Georgia's state standard code includes rough cut lumber to be able to be used such as in shops, barns, sheds. I ask you to vote green for the great people of the great state of Georgia. Thank you. I yield the will.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 1384? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing with the report of the committee which is favorable to the passage of the bill? The chair hears none. And the report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 49, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 11th.
Mr. President, I request House Bill 969 be removed from the table.
Mr. Secretary, can you please read the caption?
House Bill 969, a bill by Representative Smith of the 18th and others. A bill to be entitled an act to amend Chapter 13 of Title 33 of the OCGA relating to insurance holding company systems, so as to update the regulation of insurance company holding systems per direction from the National Association of Insurance Commissioners, to provide for definitions, to provide guidelines for group capital calculation in insurance company holding systems, to provide guidelines for liquidity stress test framework for in insurance company holding systems, and for other purposes. Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Burke of the 11th District Chairman. That completes the order, Mr. President.
The senator from the 11th has asked that House Bill 969 be taken off the table. Is there objection? The chair hears none, and it's taken from the table. The chair now recognizes the doctor from Bainbridge to present House Bill 969.
Thank you, Mr. President. House Bill 969 is a Department of Insurance bill that provides transparency to the holding company system. It's also required for NAIC accreditation. I'd appreciate your support, and I'll yield the well.
Any other senator wish to speak for or against the measure? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 50th.
Thank you, Mr. President. I move to remove from the table House Bill 92.
Mr. Secretary, please read the caption.
House Bill 92, a bill by Representative Gamble of the 15th and others, a bill to be entitled an act to amend Code Section 31-10-25 of the OCGA relating to disclosure of information contained in vital records and transfer of records to state archives and for other purposes. Mr. President, the Senate Committee on Government Oversight recommends that this bill do pass by substitute. Respectfully submitted, Senator Harbin of the 16th District Chairman. Mr. President, the Senate Government Oversight Committee offers the following substitute to House Bill 92, a bill to be entitled an act to amend Code Section 31-10-25 of the OCGA relating to disclosure of information contained in vital records and transfer of records to state archives and for other purposes. That completes the order, Mr. President.
The senator from the 50th is asked for unanimous consent that House Bill 92 be taken off the table. Is there objection? The chair hears none, and it's taken from the table. The chair now recognizes the senator from the 50th to present the measure.
Thank you, Mr. President. This is a simple, straightforward bill. What it is doing is it is decreasing the number of years from 100 to 75, the number of years that have elapsed after the date of death or application for marriage or divorce, dissolution of marriage or annulment, for the records to be transferred to the state archives. And if there's any questions, I'm happy to take them.
Did you ask if there was questions?
Yes.
Chair recognizes the good senator from the 41st with a question. To your right.
Does the good senator yield?
I do.
So, Senator, is it true that if someone were to get divorced kind of secretly 75 years ago, that this would become open and a matter of public record if we were to pass this?
Yes, 75 years from now, it would be sent to the state archives.
And would it be further true that that information, therefore, would be searchable by anybody who might want to out them for their secret divorce?
Yeah, right now it takes 100 years. This would make it 75. So in 75 years, it would be transferred to the state archives.
All right, thank you.
Thank you.
You don't appear to have any more questions.
Thank you, Mr. President. I yield the will.
Does any other senator wish to speak for or against House Bill 92? The chair sees none. The question now is on the adoption of the committee substitute. Is there objection to adoption of the committee sub? The chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute? All those in favor vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 49, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 32nd.
Thank you, Mr. President. I move that House Bill 1039 be removed from the table.
Ms. Secretary, please read the caption.
House Bill 1039, a bill by Representative Jackson of the 128th and others, a bill to be entitled an act to amend Code Section 48-7-40.34 of the OCGA relating to tax credit for Class 3 railroads and reporting so as to extend the income tax credit for expenditures on the maintenance of railroad track owned or leased by Class 3 railroads and for other purposes. Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Hufstetler of the 52nd District Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to House Bill 1039, a bill to be entitled an act to amend Article 2 of Chapter 7 of Title 48 of the OCGA relating to imposition, rate, commutation, exemptions, and credits relative to state income taxes and for other purposes. That completes the order, Mr. President.
Senator from the 32nd has asked for unanimous consent that House Bill 1039 be taken off the table. Is there objection? The chair hears none, and it is removed from the table. The chair recognizes the good senator from the 32nd to present the measure.
Thank you, Mr. President. This bill is to help our rural health care. It provides for a rural health care professional tax credit of $5,000, and it expands the people who are eligible. So now, in addition to physicians, it would include dentists, nurse practitioners, and physician's assistants with a 5-year cap and an aggregate cap of $2 million. Be happy to answer any questions.
You don't appear to have any questions.
Thank you. I yield the well.
Chair recognizes the senator from the 17th to speak to the measure. He waves. Chair now recognizes the appropriations chairman. He waves. You want me to keep going down the row? No, we're not recognizing the rules chairman. Any other senator wish to speak for or against the measure? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee sub? Chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 1st.
Mr. President, I request that House Resolution 204 be raised from the table.
Mr. Secretary, please read the caption.
House Resolution 204 by Representative Gillard of the 162nd and others, a resolution recognizing Judge Willie J. Lovett Jr. and dedicating a building in his memory and for other purposes. Mr. President, the Senate Committee on Rules recommend that this do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd District Chairman. Mr. President, the Senate Committee on Rules offers the following substitute to House Resolution 204. A resolution recognizing Judge Willie J. Lovett Jr. and dedicating a building in his memory and for other purposes. That completes the order, Mr. President.
Senator from the 1st has asked for unanimous consent that House Resolution 204 be raised from the table. Is there objection? Chair recognizes the senator from the 1st to present the resolution.
Thank you, Mr. President. This has to do with naming a building for Judge Willie Lovett. Distinguished career, Yale undergrad, Harvard Law School, clerk to 11th Court Circuit Appeals, legal career of 25 years, and was judge juvenile court. It is a juvenile justice center, YDC, that's being built, and this is asking for that building to be named after him. Ask for your favorable consideration.
You don't appear to have any questions. Any other senator wish to speak for or against the resolution? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee sub? The chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the adoption of the resolution by substitute. All those in favor vote yea. Opposed nay. The Secretary will unlock the machine. On the adoption of the resolution by substitute, the yeas are 53, the nays are 0. This resolution, having received the requisite constitutional majority, is therefore adopted by substitute. Chair recognizes the senator from the 8th.
I'm going to see if I can do this like the rules chairman. Mr. President, may I please humbly ask that HB 1331 be catapulted from the table.
I'm not certain he's humbly asked for anything, but I like to try. Mr. Secretary, please read the caption.
House Bill 1331, a bill by Representative Meeks of the 178th and others, a bill to be entitled an act to amend Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to the State Employment Service and the Employment Security Administrative Fund and for other purposes. Mr. President, the Committee of the Senate on Appropriations recommends that this bill do pass. Respectfully submitted, Senator Tillery of the 19th District Chairman. That completes the order, Mr. President.
The short and to the point senator from the 8th has asked that House Bill 1331 be taken from the table. Is there objection? The chair hears none, and the chair recognizes the senator from the 8th. We've only got 4 hours till dinner.
I'll try to do it in 3, Mr. President. Today I bring to you Governor's Bill 8, it's HB 1331. It has to do with the WIOA funding, which is a 4-title federal program, contracts with the states. The technical colleges are already handling 2 of the titles. This deals with the Wagner-Pizer part of it, which is the Title III part. Duplicate services, Department of Labor and technical colleges are doing the same thing. And so what we're doing is moving the employment services part of that money to the technical colleges. They've already, with all the other programs that they have been handling, they far exceed the national average. It's just a good bill, customer service bill. The technical colleges already have the contacts with the employers, and they also can help the folks that are looking for employment continue their education. So if I have any questions, be glad to take them.
I never thought I'd say this, but you actually did that too quickly. And there's a lot of questions.
Okay.
Chair recognizes the distinguished rules chairman to your left.
Thank you, Mr. President. Senator Yield.
Yes.
Isn't it true that you're the governor's 3rd favorite floor leader? So would you say this is a governor's bill?
Yes, sir.
Chair recognizes, continuing down the row, the senator from the 18th with a serious question.
Thank you, Mr. President. Does the senator yield?
Yes, sir.
Senator, you very eloquently presented this bill on the substance, and I just really have one question. Do the origins of this legislative initiative come from the governor's office?
Yes, sir. Governor Brian P. Kemp.
Okay. Thank you for clearing that up, Senator. That's all I have.
Thank you, Senator.
The chair now recognizes the senator from the 19th with another serious question.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, is this a governor's bill?
Yes, sir.
The chair now recognizes the next senator in that aisle, the senator from the 17th.
Does Senator Yield?
Yes, sir.
Senator, you mentioned this was a governor's bill. Did you run this by the 2 full leaders for the governor before you presented it?
Yes, sir, I did. I think with that, Mr. President, I'm going to yield away a lot. I ask you your favorable consideration.
That was going to be my advice. Does any other senator wish to speak for or against House Bill 1331? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question on the passage of the bill. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. For what purpose does the minority leader rise?
Mr. President, is it not true that the senator left the well without confirming whether that was the governor's bill or not?
I'm certain he's going to head your direction and tell you all about it. For what purpose does the good senator from the 20th rise?
Parliamentary inquiry,
State
please.
your inquiry.
I think I understood, I'm not clear on this, but I think I understood that this was the governor's bill, but I wonder if the esteemed governor's floor leader ran it by the lieutenant governor's floor leader.
All of a sudden, I'm seeing a bunch of red buttons up here. You're going to learn. On the passage of the bill, the yeas are 42, the nays are a strong 9. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 16th.
Mr. President, would you lift from the table, elevate it, just bring it off, HB 1045.
I can only ask the question. I can't do it myself. Mr. Secretary, please read the caption.
House Bill 1045, a bill by Representative Gaines of the 117th and others, a bill to be entitled an act to amend Chapter 9 of Title 34 of the OCGA relating to workers' compensation so as to extend the time period for the dissolution of the subsequent injury trust fund and for other purposes. Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass by substitute. Respectfully submitted, Senator Burke of the 11th District Chairman. Mr. President, the Senate Committee on Insurance and Labor offers the following substitute to House Bill 1045. A bill to be entitled an act to amend Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to employment security and workers' compensation, to extend certain provisions relating to the rate of employer contributions, and for other purposes. Mr. President, Senator Harbin of the 16th offers the following amendment, number 1, to amend the Senate Committee on Insurance and Labor substitute to House Bill 1045 by replacing lines 1 through 3 with the following: to amend Titles 33 and 34 of the OCGA relating to insurance and labor and industrial relations, to change certain provisions relating to life and unemployment insurance and workers' compensation, to provide for life insurers' requirement to review the National Association of Insurance Commissioners' Life Insurance Policy Locator Service, and for other purposes. That completes the order, Mr. President.
Senator from the 16th is asked for unanimous consent that House Bill 1045 be taken off the table. Is there objection? Chair hears none, and it's removed. Chair recognizes the senator from the 16th to present the measure.
Thank you, Mr. President. The underlying bill does several things. It delays a tax rate increase on the unemployment compensation tax. The subsequent injury trust fund was placed into place as it's being terminated for people who were injured on the job, and then you hire them, and it was paying for their secondary injuries that were there. That fund is being dissolved over time. The bill extends the sunset and locks in the increases. It adds another board member to the Board of Trustees, and it will delays the dissolution of the fund until 2026. It also requires an annual reporting from the fund administrator to the fund. The endorsement, or excuse me, the amendment, the second amendment that was presented, is a bill that we passed out of this chamber unanimously, and it simply does this for the citizens of Georgia. It requires the life insurance companies of this state that do business in this state to check the national database. And if you want to find a policy on a person, you can look at the National Association has a policy locator, but there's no teeth to it. And what this does, it requires each company to check that at least annually, so you could find a life insurance policy on the loved one that you've got that has passed away. So it's a way to find a policy when you don't know if there is a policy. And that passed out of here unanimously last year, and that's what it does. No question.
You do have a question. The chair recognizes the senator from the 27th to your right.
Thank you, Mr. President. Chairman Neal.
Yes, sir.
Can you tell us more what the subsequent injury trust fund is and what the pathway is out of it? Because I understand it was stated that while this bill is only extending it to 2026, that the chairman actually said that it's going to be extended to 2042. And I know this is costing us $150 million. In this year's budget, it's going to be another $300 million in the time of the sunset, and I'm just concerned that we're continuing to pay hundreds of millions of dollars for this. I'm wondering where the value is for the taxpayer.
In the committee meeting that we had, actuarially, they've got enough money to deal with the claims that are there, understanding that these are claims that have occurred prior when you hired someone, and you would hire them, and if they were injured and there were subsequent loss because of not injury on the job when they were hired, but because of past injuries. What this does is extends that so that there's adequate funding, and the idea behind it, as it was explained to us, was to dissolve the plan, and that money would go back into the general fund once that's satisfied.
Thank you.
Okay, thank you.
You don't appear to have any more questions. The chair recognizes the senator from the 36th to speak to the measure.
Thank you, Mr. President. Colleagues, I wanted to share some information about this House bill. I think it's safe to say that a lot of us don't consider ourselves expert on this subject matter of the Unemployment Insurance Trust Fund, but it has risen to the level of attention when we look at what the track record of the Labor Department has been as jobs shut down and claims were filed for uninsurance for the UI checks of people all across the state, and there was a huge backlog, a huge draw on the fund, and many, many people poorly served by the department. It caused great concern all across the state and still does. One of the parts of this bill extends the suppression of the employer contribution rate and their assessment of administrative assessment for 4 years. Now, the new Department of Labor Commissioner will be elected this year and will take over that job, and frankly, that's when we should make a decision about what to do about the trust fund. Suppressing the employer contribution rate is actually unwise, and this bill proposes to reduce it below what state law would require. And the evidence and the plain facts, folks, are that the trust fund is far below solvency, and it needs adequate funding to be restored to solvency. I could give you the numbers and the details. It's late in the day, but the trust fund is not currently at an adequate level of solvency, not enough money there. And the big news is that federal COVID dollars are being diverted to prop up the unemployment trust fund. The governor diverted $1.6 billion in federal CARES Act money away from helping families hard hit by the pandemic into the unemployment insurance trust fund. And there's more that's being proposed to be diverted. The DOL has requested an additional $800 million from the governor for the $4.8 billion from the $4.8 billion Federal American Rescue Plan Act and state and local fiscal recovery funds. More than twice the total amount the governor made available for grants to address negative economic impact to Georgians harmed by COVID. So what you're doing when you vote on this bill, you are excusing employers for 4 years from paying their administrative assessment fee and the employer contribution rate into the fund. Georgia has one of the lowest employer contribution rates to the unemployment system in the country. Last year we were 43rd in the nation. So these are facts I don't expect many of us to have our arms around at this point. It's complex, but what the bottom line is, we're spending federal COVID funds to put into that fund and excusing the employers from their obligation. Some of you may say that is fine, but I'd say wisdom would dictate that we need a full administrative assessment to have the resources to operate properly and update badly needed technology. We saw the situation when our constituents could not get any kind of timely service out of the Department of Labor. Folks, it was a crisis. Do you know what other states did? They brought in the National Guard to staff the phones and the call centers in order to serve our citizens who were in need. You know, people lost their homes, they lost their cars, they went into all sorts of temporary housing because they didn't get that unemployment check that was due to them in any kind of timely way. And we're now faced with people who got an unemployment check now hearing from the Department of Labor, oh, that was a mistake and you've got to refund what came to you. So you can see that there are numerous issues here, and to pass this bill in haste would be, I think, very, very misguided, to say the least. We now are heartened that with the pattern from the federal government, all those folks that you know that have gotten a letter from the Department of Labor saying, you owe us money, we issued you more money than you were due, and you now have to pay it back. And this is for people who don't have an extra $300, much less $1,000 or $2,000. The good news there is that the Department of Labor, following the federal leadership, has set up a process for people who are being told that they have to pay that back money. There's a process for that to be waived. If you have any constituents that are in that situation, have gotten this frightening letter from the Department of Labor, get word to them that there is now an appeals process that's been set up to waive relieve people of having to pay back that money. That is a sidebar, but it's not an unimportant one if you know people that have gotten that kind of letter from the Department of Labor. But I will yield for questions, but I would think that the wisest thing to do would be to work on this issue. I had an amendment to propose that the new Commissioner of Labor next year take all this and assess it. And we ran into as the chairman from the 16th will tell you, we ran into a kerfuffle on getting that amendment on your desks in a timely manner. But it would simply change the date to 2023 and let the Labor Commissioner get their arms around this situation. But for goodness sake, don't dig a deeper hole than we've already got over there by this careless removal of employers' responsibility to pay into that fund. If there are any questions, I'll yield. If not, I'll yield the well, Mr. President.
Chair recognizes the senator from the 32nd to your left with a question.
Does the senator yield?
Thank you. Yes.
I had a couple questions, Senator. Isn't it true that the Subsequent Injury Trust Fund is already moving to the Office of the Commissioner of Insurance?
Yes, the bill has different sections, and originally the main section was the Subsequent Injury Trust Fund, which is going through a transition and being moved, as the lady from the 32nd states. That's right. So I'm not taking issue with that at all. That's a work in progress.
Would you further yield for
Thank
a couple
you.
more? Isn't it also true that this bill adds representation from injured workers?
For the Subsequent Injury Trust Fund.
Correct.
Yes, it does. And it digs a 4-year hole in relieving employers of paying into the Unemployment Insurance Trust Fund. That's my concern.
Do you yield for one more? Isn't it true that it adds a reporting requirement to the General Assembly that doesn't exist now, so that we can keep up with what the Subsequent Injury Trust Fund is doing?
That's right. Subsequent Injury Trust Fund's been over there in the shadow. We don't want to leave the Unemployment Insurance Trust Fund in the shadows. We saw what happened. The fund is not solvent now, and we need to be bringing in the employer contributions to the fund, not suspending them. And I would support suspending for 1 year only. No further questions. I'll yield.
You have no more questions. Does any other senator wish to speak for or against House Bill 1045? The chair sees none. What purpose does the senator from the 11th rise?
Mr. President, I'd like to move to table House Bill 1045.
There's no debate on that. The senator from the 11th has moved that House Bill 1045 be placed on the table. Is there objection? The chair hears none, and it's placed on the table. Chair recognizes the senator from the 29th.
Mr. President, in honor of Theodore Roosevelt and the lakes and streams that exist here in our beautiful state, I move that the Senate disagree to the House substitute to SB 516.
Mr. Secretary, can you please read the caption?
Senate Bill 516, a bill by Senators Robertson of the 29th and others, a bill to be entitled an act to amend Part 1 of Article 2 of Chapter 8 of Title 12 of the OCGA relating to general provisions of solid waste management so as to require that the Environmental Protection Division to contract with the Department of Revenue to collect certain fees, to specify the manner in which funds appropriated to the Solid Waste Trust Fund shall be used and for other purposes. Mr. President, the House Committee on Ways and Means recommend that this pass by substitute. That completes the order, Mr. President.
Senator from the 29th has moved that the Senate disagrees to the House substitute to Senate Bill 516. Is there objection? The chair hears none, and this Senate has disagreed. All right, we're now moving on to list number 2 that has been placed on your desk previously. Chair recognizes the senator from the 50th.
Thank you, Mr. President. I move to remove from the table House Bill 554.
Mr. Secretary, please read the caption.
House Bill 554, a bill by Representative Gunter of the 8th and others, a bill to be entitled an act to amend Article 9 of Chapter 14 of Title 44 of the OCGA relating to lis pendens so as to revise when an action may operate as a lis pendens, to require issuance by a court, to provide for procedures and qualifications for issuance, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th District Chairman. Mr. President, the Senate Judiciary Committee offers the following substitute to House Bill 554, a bill to be entitled an act to amend Chapter 14 of Title 44 of the OCGA relating to mortgages, conveyances to secure debt, and liens, so as to revise when an action may operate as a lis pendens, to provide for lis pendens docket, indexing, and recording fees, to provide for entry of dismissal, settlement, or final judgment, and for the purposes. Mr. President, Senators Jordan of the 6th and others offer the following amendment number 1 to amend the Senate substitute to House Bill 554 by striking on line 6 in non-domestic relations matters, by striking on line 7 in non-domestic relations matters, by striking lines 15 through 56 and inserting 44-14-610 and for other purposes. That completes the order, Mr. President.
Senator from the 50th has asked that House Bill 554 be taken from the table. Is there objection? The chair hears none, and it's taken off the table. The chair now recognizes the senator from the 50th to present the measure.
Thank you, Mr. President. I rise today to bring you House Bill 554. This bill deals with lis pendens, which is Latin for suit pending. What it does is it does two main things. Number one, if someone files a lis pendens against a piece of property and that lis pendens is dismissed, the person who brings the lis pendens is responsible for recording that. The second thing that it does is allows a property owner to object to a lis pendens, and the court, would have to hear the objection. There's a friendly amendment, and I'd like to yield the well to the senator from the 6th to explain her amendment.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 554? Chair recognizes the senator from the 6th to present amendment number 1.
Thank you, Mr. President. This amendment is pretty straightforward. In the version of the bill before us, domestic lawyers, that is, divorce lawyers, were carved out of these new requirements. There's really no reason for certain cases not to have to comply with this new rule. This amendment just changes the bill so that it applies to all cases where a lis pendens has been filed when the disposition or ownership of real property is at issue in a lawsuit. Thank you. I yield the well.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 554 or amendment number 1? The chair sees none. All right, we'll take up the adoption of amendment number 1. Is there objection to adoption of amendment number 1? The chair hears none, and amendment number 1 is adopted. Now the questions on the adoption of the committee substitute as amended. Is there objection to the adoption of committee substitute as amended? Chair hears none. The committee substitute as amended is adopted. Is there objection to agree to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 17th.
Mr. President, I ask unanimous consent that House Bill 389 be removed from the table.
Mr. Secretary, can you please read the caption?
House Bill 389, a bill by Representative Jones of the 25th and others, a bill to be entitled an act to amend Chapter 8 of Title 34 of the OCGA relating to employment security, so as to change the definition of employment to include services performed by an individual for wages unless the Department of Labor makes a contrary determination based on evidence that such individual has been and will continue to be free from control or direction over the performance of such services and for other purposes. Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass by substitute. Respectfully submitted, Senator Burke of the 11th District Chairman. Mr. President, the Senate Committee on Insurance and Labor offers the following substitute to House Bill 389, a bill to be entitled an act to amend Chapter 8 of Title 34 of the OCGA relating to employment security so as to change the definition of employment to include services performed by an individual for wages unless the Department of Labor makes a contrary determination based upon evidence that such individual has been and will continue to be free from control and for other purposes. That completes the order, Mr. President.
Senator from the 17th is asked for unanimous consent that House Bill 389 be taken off the table. Is there objection? The chair hears none. Chair recognizes the senator from the 17th to present the measure.
Thank you, Mr. President, members of the Senate. House Bill 389 This bill deals with an issue of misclassification of workers, and it basically just codifies a standard that will be used when someone's trying to determine whether or not an individual is an employee or an independent contractor. Happy to answer any questions.
Chair, you have no questions.
Sure.
Somebody pushed your button. I wonder who it is.
Senator from the 19th, you have a question? Okay.
He
I'll yield the
waves.
will.
Well, you get the budget passed, and now I'm going to leave it alone. End on good terms. Any other senator wish to speak for or against House Bill 389? Chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee sub? The chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 14th.
Thank you, Mr. President. I ask unanimous consent to remove HB 1 from the table.
Mr. Secretary, please read the caption.
House Bill 1, a bill by Representative Bonner of the 72nd and others, a bill to be entitled an act to amend Chapter 1 of Title 20 of the OCGA relating to education generally, so as to provide for public forums at public institutions of higher education, to prevent the creation of free speech zones at public institutions of higher education and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
Senator from the 14th is asked unanimous consent that House Bill 1 be taken off the table. Is there objection? Chair hears none. Recognizes the senator from the 14th to present the measure.
Thank you, Mr. President. House Bill 1 will protect and clarify the First Amendment rights our students should enjoy on our public colleges and universities. The bill seeks to accomplish this in two ways. First, by protecting what students may say. Second, protecting where they can exercise free speech. It protects what students can say by ensuring that public universities and colleges do not ban expressive activity while on campus, so long as their conduct is lawful and does not disrupt the functioning of what that college or university is doing. It protects where they can speak by banning so-called free speech zones or areas of campus that are designated for free speech, rather than all the commonly accessible areas of campus. It also clarifies that universities can impose published reasonable time, place, and manner restrictions on speech that are content neutral and not directed toward a specific group. To note, it only applies to public universities and technical colleges in Georgia. 2, it prohibits universities and colleges from banning any expressive activity, free speech, while on campus as long as their conduct is lawful and does not disrupt the functioning of the university. Mr. President, with that, I'll yield the well. I'm sure we have people that would like to speak to this issue.
Chair recognizes the senator from the 42nd to speak to the measure.
Thank you, Mr. President. On Friday, this Senate body passed a bill, HB, I think it was 1084, censoring speech in K through 12 education, which was the quote-unquote divisive concepts bill. We also had our own version under a different Senate bill number. The driving principle behind that bill passed Friday, as far as I can tell, is that speech about systemic racism should be censored in public schools. That bill originally was generated by the Heritage Foundation. But now, our next convening later, we are poised to pass legislation with a diametrically opposite premise. This legislation that is under consideration at the moment is brought to us by another interest group, the American Legislative Exchange Council. And it is worth noting that right before this legislation was issued and written and disseminated across the nation by ALEC, there was an event at the University of Florida where counter-protesters tried to drown out a speech made by Richard Spencer, the well-known and notorious white supremacist. And that incident was just a few short months after the events at the Unite the Right rally in Charlottesville, Virginia. So my point is that having these two bills, 1084 and 1, passed together, telegraphs that this chamber and the majority party in charge of it isn't really operating under any particular principle related to free speech. And then when you add in the passage of SB 171 out of this body, which was the bill tightening up a lot of requirements on protests, requiring permits for that type of speech. Also, that legislation does not make an allowance for spontaneous assembly, which is something that is protected under the Constitution. When you add all that together, it's sort of head-scratching and frankly a little bit incomprehensible as to what policy or thought process this body is operating under as it relates to free speech. So on the one hand, the majority is aiming to censor discussion of systemic racism in an educational environment. But on the other hand, the majority is aiming to protect the speech of white supremacists in an educational environment. A high school senior will graduate under the strictures of HB 1084, where we have insisted that there be no discussion of systemic racism. And 2 months later, matriculate to a different public university, school in Georgia, where we have defined public forums and protected divisive speech. My guiding principle is that the First Amendment makes HB 1084 problematic and this bill, HB 1, unnecessary. What it looks like is that we are somewhat thoughtlessly pandering to interest groups and misinformed citizens who have been spun up to fear things that don't exist at any scale. Certainly not a scale that should invite state-level legislation. We should absolutely protect free speech. And good news, the First Amendment to the U.S. Constitution already does just that. And importantly, if we are going to add on to that and the huge body of constitutional court law that already exists in the free speech context, we should attempt to do so in a way that has some intellectual continuity and doesn't seem so blatantly hypocritical. Additionally, there are a couple of more substantive issues with this legislation. First, it contains unacceptably vague language around what is allowed or disallowed for counter-protests, and most concerningly to me, gives carte blanche for any guest of any person affiliated with the university to speak. It allows for a minor, fleeting, or brief disturbance of the speech, but it does not allow for an unquantified, loud or sustained noise or vocalization. Pretty vague, hard to know what's going to be allowed or disallowed. Another thing that I think is worth noting is that colleges and universities are a unique environment. They're not like the rest of public spaces. And that's because community and educational spaces are intertwined. With living spaces on campuses, students don't always have a choice where they live. So we do want our college administrators to have some leeway to protect students, many of whom are barely adults, from hate speech that disrupts the academic community. One good note is that this bill has been amended from the version that passed out of here several years ago, and an important change was made. At that time, the universities were opposed to the bill. This version does give them a little bit more leeway in time, place, and manner restrictions. But fundamentally, this bill still displays a hypocrisy that the majority party is eager to censor left-wing views and speech while trying in the same breath to bolster right-wing speech. Thank you, Mr. President. If there are no questions, I will yield the well.
You have a question. Chair recognizes the senator from the 33rd with a question.
Thank you, Mr. President. Will the senator yield?
Certainly, to my friend from Cobb.
Is it correct for us to understand that you are not comfortable with the message sent from the Georgia Senate chamber by these two bills you just discussed?
I think they lack, Senator, an intellectual through line that establishes any sort of guiding foundational principle as it relates to free speech. And one indicates we don't value free speech, the other one indicates we do. And so I find them hypocritical and frankly just pandering to incidents that are really not of consequence, inviting any need for state-level legislation to people who are frankly misinformed and have been spun up by right-wing media.
You have no more questions.
Thank you, Mr. President. I yield the well.
The chair recognizes the senator from the 48th to speak to the measure.
Thank you, Mr. President. I wanted to ask this as a question, but now we'll just talk about it up here. My points relate to some very specific lines in the bill. So the question is about lines 138 through 143. In these lines, the bill reads that, quote, conduct or expressive activity shall not be considered a material or substantive disruption if it's minor, brief, or fleeting and isolated and short in duration. So that's lines 138 to 143. In line 135, it also refers to speech that would be considered materially or substantively disruptive as that which creates a, quote, loud or sustained noise or vocalization. So my concern here is it doesn't quantify what is considered loud or brief, et cetera. For example, it doesn't say that a loud noise would be greater than 100 decibels, or a noise that would be audible at more than 200 feet, something like that. And it doesn't say that brief is less than 30 minutes. It doesn't give any quantitative definition of these terms. So my concern about this is, given that this bill is presented ostensibly to protect free speech, my concern is that the parameters for permitted speech as defined in the bill are too vague, which I worry could lead to subjective or arbitrary enforcement, which could actually have the effect of allowing schools to squelch free speech, which I'm sure is not what the author of the bill wants. That is my point. I will yield for questions, or I will yield the well.
You don't appear to have any questions.
Thank you.
Does any other senator wish to speak for or against House Bill 1? The chair sees none. Is there objection to agree in the report of the committee which is favorable to the push your button. Snapping fingers don't get my attention at the right times. Chair recognizes the senator from the 14th to close the debate.
My apologies, Mr. President. It's interesting that you're hearing the debate that this is quelching freedom of speech and it's unnecessary. You know, it's interesting if we look at this, Georgia Gwinnett College, and I'm not even going to attempt to try and pronounce the name, but Uzaganamba versus Presnick, that case. Let's go to Kennesaw State University, Young Americans from Freedom versus Harmon. Let's go down to Kennesaw State again, Christie versus Owens. Let's go to University of Georgia, Young Americans versus Liberty. Go to Valdosta State, Barnes versus Zakari. Let's go to Georgia Tech, Sklar versus Clow. Let's go to Savannah State, Commission 2, Love versus Yarborough. University of Georgia, once again, Beta, Kai versus Adams. Ladies and gentlemen, I can go on and on. That right now, there is no freedom of speech on here. That's why this is necessary. It ends these speech zones by protecting where and when all students can speak. So when it is, the narrative is somehow we're quelching the left while allowing the radical right to speak, that is fundamentally untrue. This avoids the overreach of alternative proposals that mandate punishments of students and protesters and creates additional help. Listen, students continue to go to school under policies that are contrary, listen to me, contrary to the Supreme Court's First Amendment precedent, harming our students as well as the university's culture, as one of the senators already said. He said, listen, this is a little different on college campuses, and you're right. And what this seeks to do is give the colleges the opportunity to make sure they're not being sued over this. Do not be misled. This is not for the right or the left. It's for all of our students. With that, Mr. President, I'll yield the well and ask for your favorable consideration.
Senator has closed the debate. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 33, the nays are 18. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 18th.
Thank you, Mr. President. I'd ask for unanimous consent that HB 1275 be removed from the table, please.
Ms. Secretary, can you please read the caption?
House Bill 1275, a bill by Representative Rich of the 97th and others. A bill to be entitled an act to amend Article 1 of Chapter 32 of Title 36 of the OCGA relating to municipal courts generally, so as to revise provisions related to appointment and removal of municipal court judges, to provide for vacancies in office and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
Senator from the 18th has asked for HB 1275 to be removed from the table. Is there objection? Chair hears none. Chair recognizes the senator from the 18th to present the measure.
Thank you, Mr. President. Good afternoon, colleagues. HB 1275 has been worked on by really all the stakeholders, and it's requested by the municipal court judges. They worked with GMA prior to filing the legislation, and what it does really is two things. It clarifies provisions relating to the appointment of municipal court judges, and it also clarifies the code sections that are currently in law about removal of municipal court judges. The code currently already provides that municipal court judges shall serve a minimum of 1 year, and this clarifies that the judges shall serve for a minimum of 1 year regardless of whether or not there's a written contract for their service. It also provides that these judges may be removed as a municipal court judge only for cause, and that the judge whose employment is being terminated is entitled to basic due process. Something we would think would be in there but is not written in the code and will be added if y'all pass the bill. With that, I'm happy to answer any questions, Mr. President.
You don't appear to have any questions.
Thank you. Urge your favorable consideration for this, and we yield the will.
Any other senator wish to speak for or against House Bill 1275? The chair sees none. Is there objection? Agree in the report of the committee, which is favorable to the passage of the bill. The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 45th for a motion.
Thank you, Mr. President. I respectfully request that House Bill 1280 be elevated from the table.
Senator from the 45th has asked for House Bill 1280 to be taken off the table. Mr. Secretary, please read the caption.
House Bill 1280, a bill by Representative Lim of the 99th and others. A bill to be entitled an act to amend Article 6 of Chapter 5 of Title 48 of the OCGA relating to municipal taxation so as to revise provisions concerning the duties of county tax commissioners with respect to the assessment and collection of municipal taxes and fees and for other purposes. Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. Mr. President, the Senate Finance Committee offers the following substitute to House Bill 1280. A bill to be entitled an act to amend Chapter 5 of Title 48 of the OCGA relating to ad valorem taxation so as to require the State Revenue Commissioner to contract with the Board of the Employees Retirement System of Georgia to offer certain county tax commissioners the option to participate in a state-administered deferred compensation plan, to provide for a limited state match of contributions and for other purposes. That completes the order, Mr. President.
Senator from the 45th has asked that House Bill 1280 be taken off the table. Is there objection? There is objection. There's no debate, and this goes right to the board. All those in favor of taking House Bill 1280 off the table will vote yea. Opposed, nay. The Secretary will unlock the machine. On the motion, the yeas are 50, the nays are 3, and House Bill 1280 has been taken off the table. The chair now recognizes the senator from the 45th to speak to the measure.
Thank you, Mr. President. Senate colleagues, I bring before you House Bill 1280. This is a bipartisan bill that passed unanimously in the House. It also passed unanimously in Senate Finance. It regards how a county tax commissioner contracts with municipalities to collect taxes, fees, and assessments, and ultimately helps ensure that our local taxpayers aren't paying more for these services than they should. In addition, this bill will set up a deferred compensation plan for county tax commissioners, which is important because despite being a constitutional officer, currently about 71 of tax commissioners in the state of Georgia are ineligible for a public retirement plan. This bill will take the current patchwork three-tier system from how it is done today, which depends on how many tax parcels are in a county and whether a county may have 14 or more municipalities, and creates one system where the county tax commissioner and the municipalities in that county have a seat at the table with equal bargaining power to negotiate these contracts. These parties must also explicitly dedicate what is approximately the cost of these services and separately what they are getting in additional compensation beyond the cost. This bill also sets a cap on these additional compensation where the county tax commissioner can receive no more than 50% of their base minimum salary. I would like to also thank a bipartisan group from Gwinnett County and the Senate delegation and the House delegation last session for initially dealing with this issue. I'm grateful for each and every one of y'all doing that. I'd also like to thank Representative Lim and Chuck Representative Efstration, for revisiting this issue to ensure uniformity in this matter. Would be happy to answer any questions, and if there are none, I'll yield the well, Mr. President.
Chair recognizes the senator from the 23rd with a question.
Mr. President, I ask unanimous consent to excuse the senator from the 20th for business inside the Capitol.
Without objection, the senator from the 20th is excused. You have no questions.
Thank you, Mr. President.
The chair recognizes the senator from the 21st to speak to the measure.
Thank you, Mr. President. And
Before I start, I want to tell you I have the utmost respect from the senator from the 45th who presented this bill, and we've worked together on a lot of things. But I rise in opposition of this bill, HB 1280. As my seatmate from the 20th says, this is a bad bill. This bill really targets 3 tax commissioners in the state, but it definitely targets my tax commissioner in Fulton County. And before our current Fulton County tax commissioner became tax commissioner, our collection rate was right about 78%. Now it's 99%. That's good for all the citizens of Fulton County. Now, I will say he does benefit financially by selling the liens and making money. I don't think that's a bad thing because I like a 99% tax collection rate. We always talk about we want to run government like business, and that's exactly what he's done, and that's a great example of that. Now, I've heard some argue that he makes more money than the president. Well, so do our presidents of our research universities, and some of our department heads that run our agencies make more than the president. And I don't begrudge anybody for making money if they do a good job and run things very efficiently. The reason I am in opposition is because of the unintended consequences. If the tax commissioner loses his incentive, our tax rate will reverse from 99% back to 78%, hurting the hardworking Georgians that are paying these taxes. The burden will fall on the individuals that are paying the taxes, and our services will have to be cut if we don't collect the taxes. I am for people paying their taxes. I am for a 99% collection rate. So I'm against this bill, and I would ask you to vote no on HB 1280. Mr. President, if there are no questions, I yield the well. You have no questions. I would ask for your opposition to this bill. Thank you, Mr. President.
Chair recognizes the senator from the 56th to speak to the measure.
Thank you, Mr. President. I want to commend the senator from the 45th for this excellent piece of legislation. We have 3 tax commissioners, the senator from 21st just mentioned, which is true, some of which are making close to $500,000 a year for doing their job. There is no one else in city, county, school, or state government that we pay $200,000 or $300,000 more a year to actually do their job. That's an insult to everyone else who comes and works every single day and does what they're supposed to do. If someone doesn't want to collect the taxes for the salary we pay them, there's an option for that. Resign, and we will put someone in place who can. This is good government. It's long past time that the Fulton County Tax Commission and other people are not making $500,000 a year for doing the job they're supposed to do anyway. Thank you. I yield the well.
Chair recognizes, for what purpose does the senator? Chair recognizes the senator from the 2nd to speak to the measure.
Thank you, Mr. President. Colleagues, I rise in opposition to House Bill 1280. Currently, in Chatham County, our collection rate is 98%. When our tax commissioner took over, it was hovering around 79%. But she got in and got the work done. Because what they're not talking about is that Chatham County is a lot like other counties. There's many other municipalities that the tax commissioner must collect taxes that are uncompensated for. So there is no incentive to collect taxes in other smaller cities when they don't get compensated for. So they need to be incentivized to do the right thing and put vigor into it. So I rise in opposition to 1280. When we look at big corporations who have multi-million dollars corporations, they make millions of dollars. And you got to look at our tax commission. They run a multi-million-dollar business collecting our money. They should be compensated for that. I rise in opposition to House Bill 1280 and urging everyone. I join forces with my friend, the senator from the 21st, to vote on this bipartisan measure, to vote against 1280. Mr. President, I'm sorry, the senator from the 21st.
Do you yield for questions?
Yes, sir.
I
Mr.
recognize him. Chair recognizes the senator from the 21st for a
Thank
question.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Would it not be true if your collection rate now goes from 98% to the 78% you said it was previously?
Yes, sir.
Your city officials or your county officials will have to cut services? Wouldn't that be true?
Absolutely.
If they don't collect the taxes?
Absolutely, sir. The senator knows of which he speaks.
Thank you.
Yes, sir. Mr. President, if there are no further questions, I
We
yield
have
the
an
way.
additional question. Chair recognizes the senator from the 56th to your left.
Thank you, Mr. President. Does the senator yield?
Yes, sir, my friend from the 56.
Thank you, Senator. Senator, could you share with us the name of the tax commissioner in Chatham County?
The name of the tax commissioner is Chatham County, I know quite well, is Commissioner Sonia Walker Jackson.
Is that a relationship to you, Senator?
Has a personal relationship with me, Senator. That's why I know so much about the tax commissioner office. Has a personal relationship. She's in the gallery. I mean, she's with us today. And yes, she also serves as my sister.
Senator, let
Proudly.
me give you a yield for another question.
Yes, sir.
So I just want to make sure I understood that. The tax commissioner whom you spoke of in Chatham County is your sister.
Yes, sir.
Senator, are you further yield?
Yes, sir.
Will you be excusing yourself from this vote?
I get no personal financial reward for voting yea or nay on this measure, sir.
Senator, can you give me one more example of anybody who serves in city, county, school, or state government that gets to take a fee from the work that they do? Can you name one position for me, please?
Well, sir, I will tell you, when we look at big businesses, when we look at corporate America, they get bonuses for the work that they do. When we look at businesses like Walmart and Delta and big corporations, they get compensated fairly for when they go over and above their profit.
Senator, if you'll further yield, we're talking
Yes, sir.
about those that work for the government. So can you please name for me one position in city, county, school, or state government that gets compensated in that manner aside from these three tax commissioners?
Well, sir, I will tell you this, that there's no other government entity that does the job of a tax commissioner. The tax commissioner's job is actually to go out and collect revenue and they don't keep this revenue, they give it to the counties, so the counties can run their operations. So their function is unique, sir. Well,
So, Senator, final question.
I will say though, sir, that when we look at sheriffs get revenue that they necessarily don't have to turn back over to the county when they resell such things like guns and they resell cars and such. That revenue goes to the sheriff's office. So that is one entity that does.
Senator, isn't it true that any revenue that is brought in from seizures and other things goes back, and there's expressly written into the law of how those dollars are supposed to be used in order to enhance public safety in the form of buying capital purchases, and has nothing to do with somebody's salary? Is that not true?
It goes back into our budget, sir, that the sheriffs have the discretion to use, at their will under the law.
Senator, isn't that absolutely an incorrect statement that you just said? That is actually governed under law to begin with, and there's nothing different. So final question. Senator, you truly believe that three people ought to get paid differently than every single person that serves in city, county, school, and state government?
I think that we should let people do the jobs that they're elected to do, sir. Thank you. Mr. President, if there are no other questions, I yield the will.
There is a question. He waves. You have no more questions. Chair recognizes the senator from the 53rd to speak to the measure.
Thank you, Mr. President. I'm glad to be here after I found my cane. Somebody must have needed it because it wasn't anywhere near me until I found it hanging on the TV camera. But I am up here in favor of this measure. It is ridiculous for an elected official to get all this extra money that is not part of his legal job. This bill kind of caps it, and that's a good thing, but to think that this is okay is ridiculous. It's amazing that should we get paid for every city, extra city that we represent or something? Of course not. This is their job, and they should not get extra money for doing it. No matter what part of their jurisdiction, that's their job. Thank you, Mr. President. I yield the well.
Chair recognizes the senator from the 29th to speak to the measure.
Thank you, Mr. President. I want to thank the senator from the 45th for this great legislation. Having worked in a large consolidated government for 31 years, having served beside an incredible tax commissioner like Ms. Lula Huff in Muskogee County, and having served with a tax commissioner like Mr. Shane Fraley in Troup County, who have 100% collection rates. They have 100% collection rates because they do their job, not because they establish a business inside of their jobs. And to be clear, any monies derived from the sale of any seized products, whether it be firearms, whether it be automobiles or electronics, are managed by state and federal law. Not a penny of that money can go into the pocket of a sheriff or a deputy sheriff. That money is very clear that it has to go into a particular portion of the budget and only can be used for one thing. Colleagues, so many of us that go into public service go in it to do the right thing. There are some that go into it hoping to get wealthy, hoping to get other things. We all know that is not the reason to go into public service. There's plenty of money to be made in the private sector, and that's where it should be. This is a great piece of legislation. It's a legislation that will tap down corruption and the temptation of corruption. Again, I want to thank my brother from the 45th for bringing this legislation forward, and I strongly urge everyone to support this legislation. Thank you, Mr. President. I yield the well.
Any other senator wish to speak for or against House Bill 1280? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee sub? The chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary will unlock the machine. What purpose does the senator from the 9th rise?
Is it true that a yes vote on this bill prevents tax commissioners from charging excessive fees to hardworking taxpayers?
That is for each and every senator to make that determination on their own. On the passage of the bill, the yeas are 45, the nays are 7. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 4th.
Mr. President, I request unanimous consent to raise House Bill 1058 from the table.
Please read the caption.
House Bill 1058, a bill by Representative Williamson of the 115th and others, a bill to be entitled an act to amend Code Section 48-7-21 relating to income taxation of corporations so as to remove the requirement that affiliated corporations file separate income tax returns with the state unless the Department of Revenue has requested or pre-approved the filing of consolidated returns, to authorize Georgia affiliated groups and for other purposes. Mr. President, the Senate Committee on Finance recommends that this bill do pass. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. Additionally, a fiscal note has been attached. That completes the order, Mr. President.
Senator from the 4th has asked unanimous consent to raise House Bill 1058 off the table. Is there objection? Chair hears none. Chair recognizes the senator from the 4th to present House Bill 1058.
Thank you, Mr. President. This is a very simple tax bill, and as was stated, this was passed 100% unanimous in the Finance Committee. House Bill 1058 proposed to allow a group of parents of subsidiary corporations to elect to file consolidated corporate income tax return, not brother-sister corporation. Currently, parent subsidiary corporations may file consolidated returns only upon advance discretionary approval from the Georgia Department of Revenue. The proposed legislation would maintain the current consolidated return filing methodology, but would remove the Department of Revenue's discretion in allowing the filings, treating all taxpayers the same. Allowing taxpayers to make the consolidated election, a small but important change, would promote predictability and uniformity among taxpayers and make our state more attractive to groups of parent subsidiary corporations. This will make it easier to do business in Georgia, and that's what we're trying to do. The Internal Revenue Service already allows this consolidation process without any permission. This bill would be effective January 1, 2023. Colleagues, I ask for your favorable support of this bill. Please press the green button. Mr. President, I yield the well.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 1058? Chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none and the main question is ordered. Question on the passage of the bill. All those in favor vote yea. Opposed nay. The secretary unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 23rd.
President, I request that House Bill 1435 be elevated from the table.
You did that better than him, and that is him. Mr. Secretary, please read the caption of House Bill 1435.
House Bill 1435. A bill by Representative Martin of the 49th and others, a bill to be entitled an act to amend subpart 2A of part 3 of Article 7 of Chapter 3 of Title 20 of the OCGA relating to the needs-based financial aid program so as to include eligibility for students with the financial aid gap and for other purposes. Mr. President, the Senate Committee on Higher Education recommends that this bill do pass by substitute. Respectfully submitted, Senator Tibbins of the 37th District Chairman. Mr. President, the Senate Committee on Higher Education offers the following substitute to House Bill 1435, a bill to be entitled an act to amend Subpart 2A of Part 3 of Article 7 of Chapter 3 of Title 20 of the OCGA relating to the needs-based financial aid program, so as to include eligibility for students with a financial aid gap and for other purposes. That completes the order, Mr. President.
So far, that was the funniest thing to happen in the Senate all day today. Great job. Senator from the 23rd has asked for unanimous consent that House Bill 1435 be raised from the table. Is there objection? Elevated, something like that. Chair hears none. Chair recognizes the senator from the 23rd to speak to the measure.
Thank you, Mr. President. And in the infamous words of Jack Hill, that's kind of funny. That's kind of funny. Colleagues, I bring you House Bill 1435. This is a gap funding, needs-based bill to assist those students in the university system that have completed 80% of their curriculum and are prepared to graduate. It fills the gap that ensures that these students graduate. It's a good bill. I encourage your favorable consideration. I yield for questions.
You don't appear to have any questions.
I yield well. Thank you.
Chair recognizes the senator from the 36th to speak to the measure. If I could get the doorkeeper to shut the door in the middle, please. The hallway's louder than I like to be able to hear the senator in the well.
Thank you, Mr. President. Colleagues, just briefly, I rise in support of this bill. It's long overdue. We are one of 2 states in the country that fail to have a financial aid program for based on student needs. Needs-based program is what they call it. 48 states have this. The author of the bill in the House is well aware of this and has worked on addressing this. This is a bill that's a start. I believe it's 4,000 students was the number that they were dealing with of what they expected to be able to take advantage of this. It's limited. It's a one-time $2,500 grant. What is important to understand is that our workforce needs, our families that are strapped, the people that counsel students as college counselors to try to get them from high school into post-secondary education, came to me and they wrote the story that they see children every day, young students who finish up and they don't have a way to go for post-secondary if they're not HOPE eligible. So there's a big cohort of students that are needing assistance that can thrive and fill the workforce and take pride in achieving post-secondary certificates and graduate, but we need to put the money on the table to make that possible, and we will be rewarded multiple overtimes from having these people be productive and working at their highest level. So I'm robustly in favor of this. We had a study committee last year, resolution that passed and went over to the House and couldn't get it embraced over there. But this is a step in the right direction, and many voices, including definitely the business community and our chambers of commerce, have urged us to move in this direction and applaud this effort. I'll take my seat and ask you to, let's give it a unanimous vote. How about that, Senator from the 23rd?
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 1435? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee sub? The chair hears none. The committee substitute is adopted. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. All right, we're going to stand at recess for about an hour. We're all going to catch our breath up here, let all of our folks be able to look at what the paperwork looks like. We'll see you in about an hour on the floor. Thank you. Stand at ease.